Good evening to all the aspirants of the TSPG-LECET 2023. You are welcome to the virtual class today that I am going to deal the mercantile law multiple choice questions. Yes, anyone can unmute and read what I posted on the screen? I said anyone can unmute and read what I posted on the screen. I repeat, anyone can unmute and read what I posted on the screen. Participants, are you hearing me?
Yes, sir. We are hearing you, sir.
But I say read what I posted on the screen.
Welcome to the aspirants of TSPG-LECET 2023 Mercantile Law virtual class on 8/5/2023.
Okay, that much is enough now. The Telangana State Postgraduate Law Common Entrance Test 2023 Mercantile Law multiple choice question. And when you say the mercantile law, what did mean? What did you mean by mercantile law? Mercantile law means source of mercantile law. There is a body of law or a legal code which deals with the international commerce, business transactions, operational like the agreements, contracts, copyright, franchising, insurance, licensing, patent, shipping, transport, trademark. These are all come under the mercantile law. But in general, that what we read, Company Act, Limitation Act, or Indian Contract Act. But precisely, Indian Contract Act and the Sale of Goods Act and the Companies Act 2013. But if you say the mercantile law, it includes, these are the acts: the Carriers Act of 1865, the Indian Contract Act of 1872, Negotiable Instrument Act of 1881, and of course we can eliminate the Presidency Town Insolvency Act and the Provincial Insolvency Act also. But we can concentrate on these, the Carriers Act, that we can concentrate on it preferably. Yes, I am making this in a different style. Yes, and Indian Contract Act also we are supposed to read it when strictly speaking what is meant by the mercantile law, and negotiable instruments also we are supposed to read, and then the Sale of Goods Act, this also comes under it. Then the Indian Partnership Act also supposed to come over there. Okay, we can eliminate if you want to the Insurance Act of 1938. See, when you say the mercantile law, you thought only Indian Contract Act. Am I right? Say yes or no.
Sir,
when I say the mercantile law, what you thought it? What are the things will be covered under it?
sir, commercial laws.
Commercial law. What comes under the commercial laws?
Yes, sir.
I say what comes under the commercial laws?
Contracts, agreements, similar matters.
When you say the mercantile law, it also covers the Company Act also. But we can eliminate because the corporate law comes, especially the Company Act. But here we can say the Carriers Act, Indian Contract Act, Negotiable Instrument Act, Sales of Goods Act, and the Indian Partnership Act. These are the acts we should have to study on the mercantile law. But don't think that mercantile law means only the Indian Contract Act. Is it clear? Say yes. Even the Arbitration Conciliation Act also comes under the Mercantile Law 1996. Now let us go to the point. First question. Dash coined the term mercantile system to describe the system of the political economy and sought to enrich the country by restraining the imports and encouraging exports. Number A, Adam Oscar. B, Smith Cauldron. C, Adam Cook. D, Adam Smith. Which is the right option among the ABCD for the first question?
Sir, B, Smith Cauldron.
WRONG.
Sir, D, Adam Smith.
Adam Smith is the right answer, and he coined the term mercantile system to describe the system of the political economy and sought to enrich the country by restraining the imports and encouraging exports. Restraining the imports and encouraging the exports. That is the point. The second question. Unmute and read the second question.
Okay, sir. Dash, also known as mercantile law or trade law, is a body of law that applies to the rights, relations, and conduct of persons and business engaged in commerce, merchandising, trade, and sales. A. Business law. B. Commercial law. C. Commerce law. D. Economic law. Sir, B. Commercial law.
Commercial law. Commercial law deals about the partnership. Commercial law deals about the trade. Commercial law deals about the sales. And these are all comes under it. Hence, the right wording for the second question is commercial law. And third question, the word derived from the Latin word dash, meaning commodity, and meaning again dash, meaning to run a trade. A. Mercari and Mex. B. Mex and Mercari. C. Mex and Mercari. D. Mex and Mercari.
Sir, B. Mex and Mercari.
W-R-I-N-G.
C. Mex and Mercari.
The right answer is D. Mex
D.
and Mercari. M-E-R-X. Mex and Mercari. M-E-R-C-A-R-I.
Sir.
Yes?
B and D both are same, sir.
Yes, you can say that, yeah, you are right. Either you can mark the B. Actually, I would like to change the X. But anyway, that both are right. Either you say the B or D. Mex and Mercari. Yes, both are the same. So that is the right answer for that one. But if you want to make it confused, yes, the X should be removed over there. Now the right answer is
D. Mex and
D.
Mercari.
Yes, that is the right answer. The Mex means commodity and the Mercari means to run a trade. The commodity to run a trade is called actually the mercantile law. And the fourth question, synonyms for the merchants. Which option is correct option or the exact option? Number one, a buyer. Two, a seller of commodity. C, the seller of commodity for a profit. D, trader. And options given in like this manner. A, 1 plus 2 plus 3. B, 2 plus 3 plus 4. C, 1 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4.
Sir, 2 plus 3 plus 4. B.
W-R-O-N-G.
Is D. 1 plus 2 plus 3 plus 4.
W-R-O-N-G. See, if you closely watch, synonyms for the merchants means synonym means similar words. Which option is the correct option? When you say the business,
2 plus 3 plus 4.
how many partners should be there? What
Yes,
are the actions? There should be a buyer. Is it clear?
buyer, seller. Yes, sir.
There should be a seller. Is it clear?
Yes, sir.
And there should the action is called trader.
Yes, sir.
But 2, 3, which is the appropriate word among the 2, 3?
2, 3. 3 is a.
3 is the appropriate word because you sell for the profit, you sell for the loss.
Yes, yes.
So you eliminate the 2. Then which is the right answer?
1 plus 3 plus 4.
1 plus 3 plus 4 is the right answer. Because the essence of doing business is to get the profit.
Profit.
Is it or not? Otherwise, it's a charitable institution.
Yes.
If it is a charitable institution, nobody could become a ADAN. Is it clear?
Yes, sir.
Good. Fifth question. Classification according to function, according to the mode of formation of the contracts, Our contracts may be classified into three, namely, number one, express contract, number two, implied contract, number three, oral contract, number four, quasi contract. Now the option A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4.
Sir, 1 plus 2 plus 4. C.
1 plus 2 plus 4 is the right answer because oral contract in the trade would not be entertained.
Yes.
Express contract will be entertained, implied contract will be entertained, and quasi contract will be entertained. But when you see the contract, even your oral contract also a contract, but it is difficult to prove. Hence, contract always should be in black and white form.
Writing. Yes.
Needs written form. Read the sixth question.
Sir, contracts can be of different types, including exact options: unilateral, bilateral, multilateral, contingent. So answer options: A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4. Sir, 1 plus 2 plus 3, A.
WRONG.
Sorry, sir. 2 plus 3. 2 plus 3 plus 4.
WRONG.
Oh.
The right answer is C. 1 plus 2 plus 4. Because unilateral contract means one side contract. Like we can find it, whoever uses the carbolic smoke balls and they will cured within the 1 week or 10 days because we are deposited 100 pounds in the Imperial Bank Imperial Bank, and that is the intention to create the legal relationship in the Carbolic Smoke Balls Company case law, Carlyle versus Carbolic Smoke Ball Company case law. It's a unilateral contract, and there is a bilateral contract. Bi means two or more. Generally, bi means two. Even if there would not be a multilateral, of course, when you say multilateral means more than two, but there is no such a thing. But the multilateral treaties are there and contingent contracts are there. But in actually, when you say the different types, we say either unilateral contract, bilateral contract, or contingent contract. So I concocted the multilateral. Hence, the right answer is 1 plus 2 plus 4. Always you have to pick from the options. There is no assumptions, no presumptions. Seventh question. Contracts can be different types. Again, I ask that, including exact option you have to choose. Number one, voidable contract. Number two, express contract. Number three, direct contract. Number four, implied contract. Options: A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 4.
So D 1 plus 2 plus 4.
You are right. 1 plus 2 plus 4, wrong. It's wrong.
Wrong, sir.
Yes. Try. There is a voidable contract, no doubt. Express contract, okay. What is a direct contract? Do you have direct contract or indirect contract?
So
you eliminate the 3.
yes, sir. That is what I did, sir. 1 plus 2 plus 4.
Yes, you are right. Yeah, eliminate the 3. 1 plus 2 plus 4 is the right answer. You are right.
Yeah, D.
Yeah.
Yes.
I would like to make you whether you could emphasize or not. Okay, that is the right answer. Now let us go to the 8th question. Contracts can be different type, including exact option again. Number 1, anticipatory contract. Number 2, future contract. Number 3, executed contract. Number 4, executory contract. And option A 1 plus 2, B 2 plus 3, C 1 plus 3, D 3 plus 4.
So 1 plus 2. A.
You check it very closely. Only 2 are correct.
Correct, sir.
Only two are correct. There is no anticipatory contract like anticipatory bail.
So 2 plus 3.
The 2 plus no 3 no. Future contracts also will not be there.
So 3 plus 4 remaining.
3 plus 4 executed and executory. Executed means past. Executor means future.
Executory, to be executed.
Yes, executory means to be executed in future. But there is no future contract, there is no anticipatory contract. Now the question comes, the ninth question. Understanding the different kinds of contract. When it comes to the contracts, there are 4 classifications, including number 1, contract based on the information, 2, contract based on the nature of consideration, 3, contract based on the execution, 4, contract based on the validity. I am speaking about the performance of the contract, where the contract kinds are. A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
Two plus 3 plus 4. B.
Yes. How could you know the D?
Sir,
B is the right answer.
Sir, I just eliminated the first one, sir. Contract based on information.
See, contract based on the information is not there. I changed it. Contract based on formation.
Yes, sir.
Contract based on formation means how the formation would be there. I mean, the host changed, means myself changed, contracts based on information. So you eliminate the one, then the right answer is 2 plus 3 plus 4 is the right answer. So that is the process that you have to do it when you are shooting it. Yes, 10th question. What are the characteristics of mercantilism? The characteristics of mercantilism are number 1, wealth, number 2, foreign trade, number 3, commerce and industry, number 4, population and natural wealth. Options: A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
Sir, 1 plus 2 plus 3. A.
Yes. Why you chosen that is the right answer? Can you tell me?
Sir, because I just eliminated the fourth one, population.
Why?
Because the population has, though their integral part of the business or trade and mercantilization, directly they have not been given any role. It's only buyer and seller.
See, when there is no population, where is the question of buyer and seller will come?
So the wording, that is what. Had it been a buyer instead of population, I would have opted.
Yes, no doubt you are right. But population is not the word. That natural resources. I removed the resources, I put the natural wealth.
Yes, yes, yes.
No doubt you shooted very rightly.
Sir.
Natural resources, population also one of the condition, characteristic. But here, natural wealth I made, but actually the natural resources are there. So when there is no natural resources and population, then only the exports and imports would be there. Suppose that there is no natural resources, then imports and exports cannot be possible, because when the abundant commodity is there, naturally it should be exported. Am I right?
Yes, sir. Yes, sir.
What India will export more?
Yeah, sir. Agri-based products, sir. Agri-based products.
Of course, not that much, but still we can say. But what about the natural resources?
Yes, sir. Of course, minerals, all kind of minerals.
Yeah, minerals, mostly the iron ore.
Iron ore.
Yes,
Granite.
mostly. And even sometimes mica also.
Yes, sir. Yes, sir. Mica also.
And because we do have a lot of mica mines. And now let us come to the 11th question. The movement of goods and services is an integral part of an economy, and the development is entwined with economic growth. The Carrier Act of 1865 lays down the right and liabilities of the dash. A. Air carrier. B. Water carrier. C. Road carrier. D. Common carrier.
Sir, can I go for D, common carrier?
You are right. Because a carrier may be anything.
Yes.
And hence, better you say common carrier. And you know that daily one plane goes to the Saudi Arabia only for the vegetables
Oh,
and greeneries. That's why you find pudina, kothmir, everything there.
oh, fresh every day.
And that to be fresh. And now let us see the 12th question. The committee had recommended repeal the Carrier Act of 1865 and the re-enactment incorporating the above requirement to achieve the following objectives. Number 1, to regulate and limit the liability of the common carriers. 2, to provide for the registration of the common carriers to regulate the carriage of the hazardous and dangerous goods. Number 3, to ensure the proper statistical reporting in the transport sector by person involved in the transportation business. Number 4, to provide for the rule-making powers to deal with the emerging and changing scenario time to time, and amend the Carrier Act of 1865. Options: A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
Sir, D, 1 plus 2 plus 3 plus 4.
If you see the question, the Common Air Carrier 1965 should be repealed. Am I right? To what? To get these following objectives.
Sir.
And the 1 is very right, 2 is very right, 3 is right, very right. But when you read the 4th, to provide for the rule-making powers to deal with the emerging and changing scenario time to from time to amend the Carriers Act, not amend the Carriers Act, to repeal the Carriers Act 1865.
1 plus 2 plus 3.
And here repeal is there. But here I also should come repeal. But I remove the repeal, I put the amend. So you eliminate the 4 and then 1, 2, 3 is the right answer.
So if it is repealed, it also comes.
Yeah, if it is repealed, no, that is the objective of it is to repeal it.
Yes.
So then definitely it will come. Then the answer is 1 plus 2 plus 3 plus 4 is the right answer. First I thought I would keep the repeal, but then I said no, we'll make the change. Whether the students will catch the point or not. Because when you say repeal, and here there is no question of amendment.
Yes, sir.
So that is the tactics we have to adapt. So that is the same thing which I did it here. To provide for the rule-making powers to deal with the emerging and changing scenario from time to repeal the Carriers Act 1865. So I removed the repeal, I put the amendment there. So now the 13th question, unmute and read.
Yes, sir. A common carrier shall be responsible for the loss, destruction, damage, or deterioration in transit or non-delivery of any consignment entrusted to him for carriage arising from any cause except the following, namely: 1. Which measure, act of God; 2. Act of for or public enemy; 3. Genocide and civil commotion; 4. Arrest, restraint, or seizure under legal process.
Options.
Sir, options 1 plus 2 plus 3, A. B stands for 1 plus 2 plus 4, C 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. Sir, D 1 plus 2 plus 3 plus 4.
See, if you closely observe it, a common carrier is not held liable for the following reasons.
Yes.
When there is earthquake, when the whirlwind, when there is a tornado, when there is a heavy rain, that is called act of God.
Yes, sir.
In the common law terminology, we say vis major.
Yes,
And
major.
the oblique which I put it is, I say in my language, that is called Polish language, virgule, virgule. Vis major, virgule, act of God. Yes, common carrier is not liable. Act
Yes, sir.
of war is there, public enemy is there, common carrier is not liable. When you come to the genocide, actually I incorporated genocide there. It is not a genocide, it is a riots. Riots and civil commotions, yes, common carrier is not liable.
Okay, so it is
Arrest,
not genocide.
restraint and seizure and a legal process, yes, common carrier will not liable. But genocide, I use a very terrific word. The word is not there in the
Yes.
envisaged points. So we can, three we can remove it. So when you remove
Yes, sir.
the
So 1 plus
three,
2 plus
then
3.
1 plus 2 plus 3 is the right answer.
1
See,
plus 2 plus 4. 3 is the
riots
right
and
answer.
civil commotions, not genocide. Of course, when the genocide also there, but riots is different and genocide is different.
Okay,
Riots
sir.
will happen now and then, but genocide will not happen. Only rarely it will happen. Is it clear?
Yes, sir.
జెనోసైడ్ అంటే తెలుగులో చెప్పండి.
రావట్లేదు సార్ సరిగా వాడు.
ఊచకోత.
ఊచకోత. ఓకే.
14th question. Scheduled and non-scheduled goods under the Carriers Act of 1865, the liability of the common carrier of the goods has been laid down. For this purpose, the Act has classified the goods into two categories. Number one, scheduled goods. Number two, unscheduled goods. Number three, non-scheduled goods. Number four, descheduled goods. Only two are correct, but I concocted, fabricated, made, falsified other two. Now option A 1 plus 2, option B 2 plus 3, option C 1 plus 3, option D 1 plus 4.
Sir, C 1 plus 3.
1 plus 3 is the exact answer. That means you use your common sense and you use what is the appropriate word for that one. Generally, unscheduled we very rarely say.
Yes, sir.
And a non-schedule also, non-schedule it is there.
Yes, sir.
And deschedule we rarely made it because there is no such a worries could be used over there, especially when the matter comes to the scheduled goods. So the right answer is 1 plus 3 is the right answer. Now 15th question. Section 11 of the Indian Contract Act 1872. If I ask you what is section 11 of the Indian Contract Act? Supplementary question.
Oh, sorry, sir.
Do you have idea? Section 11, competency to the contract of the Indian contract. Who are competent to contract? Answer is every person is competent to contract. Who is? The following conditions should be fulfilled. Number one, of the age of majority according to the law to which he is subject, and who is number two, of sound mind, number three, a sound body, and number four, not qualified from the contracting by any law to which he is subject. Now the options: A 1 plus 2 plus 3, B 1 plus 2 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
Sir, B 1 plus 2 plus 4.
Yes, that means your logic you used. There is a meaning of the age of majority is there, no doubt. Sound mind would be there, but not necessarily sound body. He should not be a Miss Universe or Mr. Universe or a karate 2 dan 3 dan. Is it clear?
Yes, sir.
Now the 16th question, unmute and read.
Yes, sir. Essential elements of an Indian Contract Act Please do not make any assumptions and presumptions. Just pick. Okay, sir. The essentials of Indian Contract Act: offer, counter offer, acceptance, awareness.
Options.
1 plus 2 plus 3, 1 plus 3 plus 4, C 1 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. Sir, A 1 plus 2 plus 3.
WRONG.
Sir, 1.
Essentials.
Sir, 1 plus 3 plus 4.
1 plus 3 plus 4. How could it be an essential counteroffer? Counteroffer means he is not accepting your offer. And it's a counteroffer means, suppose you want to sell the rice, say about 100 kilos, say about 50,000 or 40,000. But he said, no, give me the 25,000. It's a counteroffer. A counteroffer is not the essential element. And hence the right answer is B.
1 plus
3 plus 4. Now the 17th question. Essential element of an Indian Contract Act. Number 1, consideration. Number 2, capacity. Number 3, status. Number 4, legality. Options. A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4. I'm sure that you can deal this one. It's very
1 plus 2 plus 4, sir.
You read first. Yes, you are right. 1 plus 2 plus 4 is there because essential element is a consideration. Essential element is a capacity. That means he should be a sound mind and age. Status not necessary. Whether it is, of course, status comes only in the child, but his status married or unmarried or aged, later we'll see, because minor contracts also valid contract. Because if you supply to the minor essential commodities, essential goods, then you can get the contract can be executed. Because
Yes, sir.
you supplied the essential. There is a very famous case law is there. I don't know whether you know it or not. Nash versus Imam. That is a very famous case law. Nash versus Imam. That is a very famous case law in the contract. And where a tailor has stitched the 3-piece suit to the Cambridge University student. And he is already having the many suits of such a nature. And 3-piece suit is not that much essential to him because he is having several suits. And hence, it doesn't come under the essential commodity or essential things. Hence, he is not going to get it. Suppose, if you have stitched the only pant and shirt, which is the more essential. Am I right?
Correct, sir.
Not 3-piece suit. Do you know what is meant by 3-piece suit?
It's a blazer kind of thing, sir.
Yes. One is not blazer actually. One is a trouser, another is a coat. But before you are wearing the coat, you wear the small one. What is that? A small coat. It doesn't have the sleeves.
That's good.
Waistcoat. That is a 3-piece coat. Okay, now let us go to the 18th question. A contract has 6 important elements so that it will be valid, which is, I gave the sequence, which is the proper sequence. A, offer, acceptance, consideration, intention to create the legal relation, capacity, certainty. B, offer, acceptance, consideration, certainty, intention to create the legal relation, capacity. C, offer, acceptance, consideration, capacity, intention to create the legal relationship, and certainty. D, offer, acceptance, consideration, intention to create legal relations, certainty, and capacity. I said sequence. A proper sequence. See, when you are wearing the pant and shirt, what do you wear first?
Sir, can I go for C, sir?
WRONG. The D is the right answer.
D.
First, there should be offer.
Okay, sir.
There should be acceptance. For there is these two transactions, there should be consideration. Am I right?
Yes, sir. Correct, sir.
Another, if the consideration also there, intention to create the legal relationship should also be there.
Correct, sir.
Otherwise, it become a puff. It become a false. If it comes intention to create the legal relationship later on, certainty is not there, no use. And the last one, capacity. Capacity in the sense age, sound mind. If you have the sound mind or no sound mind, on behalf of you, your father, guardian, somebody will take it. Am I right?
Yes, sir. Correct, sir.
If you are a minor, the same thing happen. So the capacity comes lost.
Lot.
When you go for the 5-star hotel, what do you eat?
Sure. It depends, sir.
First, what it is served first?
The first comes soup.
First comes soup. Next,
Next, sir, snack kind of thing.
and bites.
Bites.
Next,
Yes.
main meal.
Yes, sir.
Next,
Next, sir, sweet desserts.
desserts. Of course, some people after eating dessert, either they go for the Coca-Cola, cool drink, or they go for the Irani chai.
Yes, yes, sir.
Because Irani chai digests everything.
Yes, yes.
Now the 19th question. Agreements without consideration except it is written and registered are a promise to compensate for something done or a promise to pay a debt barred by the limitation law. Which one is the correct option? Number 1. Agreements in restraint of marriage. 2. Agreements in restraint of contract. 3. Agreement in restraint of trade. Number 4. Agreements in restraint of legal proceedings. Options: A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4.
Sir, B, 2 plus 3 plus 4.
Closely observed is the wrong option. See, if anybody make an agreement of a restraint of marriage, it is a white.
Right, sir.
If anybody make an agreement in restraint of a trade, it is a white. Agreement in restraint of legal proceedings, if anybody wants to make it, it is a white. What about the agreement in restraint of contract?
Yeah, it is okay.
Some contract you can restrain it. Suppose if the contract is for the illegal purposes,
Yes, yes.
or if the contract is for the prostitution,
Yes, yes. Which is banned
it's
by
not
the law. Correct, sir. So the answer is 1 plus 3 plus 4.
answer is 1 plus 3 plus 4 is the right answer. See, somewhere they will give us such a question also. Because I am made the very critical one, so that if any question comes now, you can easily shoot out.
Yes, sir.
So 28th question, which one is the correct option? Number 1, agreements void for uncertainty. 2, agreements by way of wager. 3, agreements contingent on an impossible events. 4, agreements to do impossible acts. Options: A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 3 plus 4. D. 1 plus 2 plus 3 plus 4. You watch closely.
No idea, sir. Unable to.
See, agreements void for uncertainty. When there is no certainty is there, definitely is a void. Suppose if you have the two houses, one is big house, another is duplex,
Yes, sir.
and which you are going to sell you did not mention. That means consensus added up, no consensus for a certainty. So it's a void. An agreement way of wager. Wagering agreements are void. Contingent agreements are valid. Agreements contingent on impossible event, yes. Impossible event contingent, it is white. A man can walk 10 kilometers in an hour, impossible.
Yes, sir.
An agreement to do impossible acts, I can buy the Taj Mahal
Yes, no, cannot buy.
because that is a property of
The government.
archaeological department.
Yes, public.
So, answer is 1 plus 2 plus 3 plus 4.
Oh,
I did not change here. Now the 21st question. Consideration must be dash. A. Past. B. Present. C. Future. D. All of the above.
yes, sir. All of the above.
All of the above is answer. A past consideration is a valid consideration.
Yes.
A peppercorn also a valid consideration.
Okay, sir.
And hence, all of the above is the right answer. 22nd question. Under Section 11 of the Indian Contract Act, an incompetent person, including A. Minor, B. Incompetent person, C. Unsoundness of mind, and D. All of the above.
So all of the above. D.
Yes, it is all of the above.
Yes, yes.
Because minor, no. Actually, of course, in general, we can say all of the above.
Yes.
Because minor can make a contract, provided conditions should be fulfilled. It should be essential.
Yes, in general, but in general.
In general, minors are exempted for the contract. Is it clear?
Yes, sir.
What is the famous case law? Minors' contracts are void. There is a very classical case law. They mortgage the property, minor property, and later on they say, I'm a minor. Hence the contract of the minor is void. It's a very classical case law.
Yes, I heard about Bengali case, sir. Bengali name.
Of course. Mohari Bibi versus Dharmadas Ghosh.
Yes, sir.
It is a very classical case law you will come across. Now the 23rd question. A little critical but doesn't matter. If you use your just technique, you could understand it. 23rd question. The court may grant to the plaintiff a perpetual or permanent injunction in the 4 cases as follows. Number 1. Where there is a standard of quantifying the actual damages caused are likely to be caused to the plaintiff by the invasion of his rights. Number 2. Where invasion of the plaintiff's right is such that any compensation in money would be inadequate relief. 3. Where the defendant is a trustee of the property for the plaintiff. 4. Where the injunction is necessary to prevent multiplicity of the judicial proceedings. These are all the four are given here. Now I am asking it. A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4. Which is the correct answer?
So 1 plus 2 plus 3.
Okay, I agree that 1 plus 2 plus 3 is the right answer. What is the wrong in the 4? You tell me.
So because it is a multiplicity of judicial proceedings. Actually, that doesn't come here.
No, if it does not give that injunction, there would be a multiplicity of the judicial proceedings are there. Actually, it is not the right answer. If you closely watch it, feedback, where there is no standard of quantifying, where there is no standard of, I removed the no.
Okay.
Where there is no standard for quantifying and the actual damage caused are likely to be caused to the plaintiff by invasion of his right, because we cannot calculate the standard of qualifying damage, and hence permanent injunction would be issued. And a permanent injunction can also be issued where invasion of the plaintiff right is such that any compensation in money would be inadequate. No, money is not important. I want that the contract should be performed, number one. Number two, injunction should be given. Number three, where the defendant is a trust property. In trust property, injunction is must, because a trustee will protect the property of the beneficiary, and hence a trust property cannot be sold. In case it can be sold by the permission of the court for the benefit of the trust beneficiaries. Is it clear?
Yes, sir.
Where the injunction is necessary to prevent multiplicity of the judicial proceedings. Suppose the injunction is not given, there the multiplicity of the proceedings would be there, and hence the right answer is 2 plus 3 plus 4 is the right answer.
B is the right answer.
Am I right?
Right, sir. Correct.
Yes. Now 24th question. Under section 36 of the Specific Relief Act 1963, an injunction is defined as an order of the competent court which, number one, A, forbids the commission of a threatening wrong. B, forbids the discontinuation of the wrong already begun. C, commands the restoration of the status quo within parentheses the former course of action. And D, all of the above. Already I shown the feedback. Jai Hind.